The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program was created to educate and inform and help you decide how to protect yourself, your family, and your business regarding legal matters. It's information and resources that'll help you manage some issues yourself, or you'll be better prepared to work with counsel should you decide to go that route. Either way, of course, our goal is always to help save you time, money, and achieve the best possible results. As always, we want to welcome our attorney, David Bazar, from the Bazar and Associates law firm in East Providence. He continues to weigh in on the various issues that we tackle each session. And today,
thank you.
And today, judges and justices, state and federal level. What about the Supreme Court, which is certainly a timely and contentious issue? Why is filling a Supreme Court vacancy in an election year such a complicated and contentious issue? We'll get into the issues such as they are today. Interestingly, 600 sit on, I guess, the district courts, 200 on the Court of Appeals. David will be weighing in on this, and we will have the 9 at the Supreme Court level. It's such an interesting process, David. So we have state and federal issues, but we also have the biggest, hottest item right now, which is Supreme Court. Give us an overview, if you would, about how judges and justices are selected and the differences, if you would.
Sure. So, as you know, as everybody probably knows, there's an opening on the United States Supreme Court because we lost Justice Ruth Bader Ginsburg, and that's the big issue that we'll talk about as we go along. There's also 2 openings on the Rhode Island Supreme Court as Justice Indeglier retired, and I think Justice Flaherty announced that he intends to retire. So those will be filled. And they're filled in very different ways. It's very political nonetheless, and the more we try to take politics out of it sometimes, the more it becomes political. But the process is in the federal instance, the president nominates somebody, and then the Senate has the right for advice and consent in confirming somebody. In the state, there's a judicial nominating commission that interviews people who apply. And then they send 3 to 5 names to the governor. The governor can select somebody, and depending on exactly which position it is, usually, again, it's the Senate that has advice and consent in a confirmation process.
You mentioned the state of Rhode Island. I guess it's important to note, too, that various states have different ways of how they're going to select, elect, or appoint judges at various levels. It was kind of interesting in doing a little background reading about this topic that in the earliest days of our colonial history, those appointments to the Supreme Court, they took a matter of days. Of course, in more recent history, they've taken 2 and 3 months, as when Judge Sotomayor came in and when Brett Kavanaugh came in. And one of the other interesting things that I noticed was that it wasn't until the 1930s that these confirmation hearings became a public grilling rather than just a discussion of their credentials. And isn't it supposed to be that it is based on some merit as well as anything else?
You would always hope that merit plays a role. It should. And in the United States Supreme Court and also the other federal courts, the American Bar Association does weigh in on stating whether someone's qualified, well qualified, not qualified. So they do a rating system. I don't know exactly what goes into that, but there is at least some review of a person's credentials for being qualified for the position through that. And the president and the Senate can choose to ignore whatever is said there anyway. It's not binding on anyone. The judicial nominating commissions on a state level are looking for qualifications, theoretically. And there is a, if you don't get through the judicial nominating commission as being qualified, then you're not going to be considered. So it's a very different process. As you said, there's also other ways that judges can be appointed or elected. In some states, you run for election. Personally, I think that's the worst process for a judge to go through, because judges need to be independent. They have to use their judgment, which is sometimes perhaps applying the law in a way that's not very popular, but it's the correct way to do it. And if you have to run for election, how is your application of the law going to be affected by your needing to run for re-election?
Such a good point, David. I remember reading that there were cases when the judges knew that they were going to be elected. Gee, might that impact on whether they wanted to make their public happy versus this is what the true interpretation of the law should incline my judgment to be. So it's a very interesting debate there.
And actually, I think it can go even beyond that.
Sure.
So if you're running for election, apparently in today's world, that costs money, so you need to raise money. So do you raise money from lawyers who are going to appear in front of you? And if you can do that, does that have at least the appearance of impropriety? If this lawyer gave $5,000 and that lawyer gave $1,000 or nothing, and that's obviously not supposed to happen and not the way it works, but does it happen? And how do you protect against that?
And of course, I think we've seen cases where the person who is running to become a judge, maybe in addition to the campaign donation, he or his cohorts would then bring business to that lawyer's firm or have a referral that went out from his state to another state and back into this state and into that lawyer's office. All of those kinds of things certainly make the waters much muddier than they should have ever been.
Yeah, as difficult and contentious and fraught with some problems as appointing judges through either a governor or a president can be, I just think it's far and away much better process than judges who have to run for election. And by the way, I was told recently there's one and only one judge position in Rhode Island that is done by election. Oh, you want to know what that is?
Yes, David.
I believe it's the probate court judge in Tiverton.
Interesting. Why would that be?
Just the way their home charter, or if they have a home rule charter, or their process has just been established, and that's just the way it is.
Interesting. And of course, there are some states where you are elected, if you're elected, it's 7 years. Other places, it's until you die in office or whatever. And of course, just the term, never mind term limits on politicians, but term limits on the time that you're going to serve as a judge is an issue too.
Some states have limitations and an age limitation.
Yes.
Yeah, and I think Massachusetts actually may be one of the states.
70 up to 70 or something?
Something of that nature. And I'm not 100% sure that's always the best way to do it either. I do think, for the most part, a lifetime appointment is important so that, again, you don't come up for a review, so you can do what you think is right and apply the law the way the law needs to be applied. There is a way of removing a judge who we think doesn't do that. And so as long as there's a process to remove a judge who's not acting appropriately, and it's actually happened in Rhode Island where that process has been invoked, then I think the lifetime appointment is appropriate. I don't really like the age limitation so much either, because people live longer and healthier lives. And
True.
Why, if it's 70, should someone who well into their 80s and beyond be eliminated from being able to fill that role if they're capable and qualified to do that?
Makes sense. Interestingly, in the Constitution, I'd read that there is, it was intentionally vague about what constitute merit, and also the issue of removal depends on just behavior. So in other words, they were really going to be there at the Supreme Court level unless they did something terribly wrong.
Just like a president, a judge can be impeached. And it's happened, and there's a process for removing judges. It's not just Supreme Court judges, it's every federal level. There's a process. And as long as that process is there, I'm not concerned about that lifetime appointment status.
When Roger Williams was talking about the lively experiment, such as it was, it's interesting, but over history, and looking at the selection of judges over history, this was the selection of judges, appointment and what has always been an issue of debate. Apparently, the colonists resented the power that the king had said, even though you have judges, he wielded power that far across the pond, and they changed it. And I had read that there were times when we had states had initially adopted appointments, then they went to elections, and then some states changed, and then somewhere by the 1830s in the Civil War, 24 of 34 states elected their judges. So this has been a contentious and ongoing issue at all levels since the beginning.
Of the United States.
Of the United States.
Yeah.
Interesting.
Yeah, and there's, because there's pluses and minuses in every system. And so maybe something's come up as the process is unfolded, and they said, hey, wait, let's change this and try a different way. And so that's what's happened.
The lively experiment continues, as they
Correct.
say. So there is Article 1, Article 3, when they talk about the how judges are selected. And if I were to ask you how are judges selected, you always say that it depends on the court, and there are various levels of courts. Right. Can you go over, give us an overview of the process?
So Article 1, Article 3 are different types of judges. And judges who are appointed under one article are not the judges you normally think of in terms of district court, U.S. Court of Appeals, Supreme Court. They're more what we call administrative law judges, judges who hear bankruptcies.
Probate?
Well, probate.
No, maybe not.
Probate in Rhode Island is that's separate. Social Security cases, for example.
Really?
Yes. Yeah.
Is that in every state or just?
No, that's federal.
Oh, it's
and remember,
federal.
Article 1, Article 3, we're talking about
Right,
the Constitution, so it's a federal appointment.
So where we are now, when it comes to selection of federal judges, the Judiciary Committee, speak to that a little bit and how that is formed and what that process is about.
Okay. So on the federal level, the president appoints judges or justices to vacancies that exist. And we can talk a little bit about both the process from the president and the Senate Judiciary Committee, because it's the Senate that weighs in. So the Senate Judiciary Committee is comprised of senators, members from each party, and of course whatever party is in the majority gets to select more members than the party in the minority. So the leader of the Senate, Mitch McConnell, will pick his senators who will be on that committee and appoint the chair, which he appointed Lindsey Graham. And so there are those senators from the Republican Party, and then Chuck Schumer, as the leader of the minority party, the minority leader, will appoint the senators that are on the committee for the Democrats. And so it's comprised of slightly more Republicans than Democrats. And the committee is invested with hearing the qualifications and the confirmation process of whatever judge or justice appointee is appearing before them. And then they vote whether to recommend that appointment to the full Senate, and then the full Senate gets to weigh in.
And apparently, while our president gets to nominate who he would like to for that seat, the senator from the state which the nominee comes from has at least some say or gets to weigh in out of respect. I guess that's part of it, and also has some valid frame of reference.
Correct.
As they go through the process.
But that's for an appointment to a seat on the district court usually. Of course, that's where the state will be in play.
Which is why they're talking about it being at times political.
Right. Everything when it comes to this process is political.
So over the time being when we've spoken about Supreme Court justices in general, it makes perfect sense that the president is going to look to appoint someone who is of his party, of his leanings. And yet, when you look at how Supreme Court justices have voted, many of those presidents have gone back and said, dang it, I wish I hadn't, because that person voted actually his conscience.
Right.
Conservative, a president who is conservative votes in or nominates a conservative justice who becomes a justice, and then the decisions on several occasions have become liberal. Why is this so much more contentious in these most recent nominations as such as we're looking at right now, David.
So the history of what you're talking about is correct, that President Nixon may have appointed somebody who thought would have been somewhat conservative and following some of the principles that he held dear, and the person may have had those, but that's what's the great thing about a lifetime appointment and a person who is well qualified. So if you're appointing a very smart, well qualified person, and they're going to grow over time, their policies, or not policies, because it's not about policies, but the way they look at the law and how to apply the law may evolve.
Evolve, exactly.
And there's nothing wrong with that. In fact, you would want that. And I believe you would want a justice who is smart, independent, and able to apply the law consistently, but in a way that is predictable. And if it doesn't follow what you wanted as the president, so what? That's not how it's supposed to work. You're just supposed to appoint someone who's well qualified and able to do the job.
And that makes such sense, David. And yet, when we talk about how in recent hearings this has become a public grilling of someone's personal beliefs or whatever, when in fact it is their job to follow the letter of the law. It's Congress's job if they want to change the law, that's a different issue. But theirs is to interpret and make sure that things are consistent. And even when Amy Coney Barrett right now is talking about...
Coney Barrett,
thank you, is being asked about Roe v. Wade and overturning it and the rest. Right now, the only thing she can say is maybe that's going to change. Maybe there's one element of it, but it's not about her personal beliefs, as you indicated, and that has been the case for everyone who's gone before these Senate hearings.
Right.
Why don't they let this go? Why so contentious?
Well, part of the problem has been that presidents have been trying to pick people who they think they have a better ability to predict what they're going to do, and therefore change the course of how the court may evolve in the future. And it's a long appointment. A young person's going to be there for a long time, and there's some truth to that. I believe, however, if you appoint a very smart, well-qualified person, you won't be able to predict exactly how they're going to find on each case, because the facts of the case and then the law as it's applied to the facts are not always going to be exactly what you thought they were or would be. And so the final application may be slightly different than you would have wanted it to be. Sorry, that's just the way it is. And that's why it's so difficult for a possible appointee to be able to say how they would rule on a case, because they don't know what exactly the particular facts are going to be and which particular area of law is going to apply to those facts until they actually get the case before them, which is why you'll often hear them say, I can't answer a question about a case that's not a case in controversy or an actual case that should be appearing before the court. And then if it is a case in controversy that's coming up, you can't talk about that in advance because you haven't heard the arguments or read the briefs, and it would be inappropriate for you to comment on how you think you would rule on a case until you've actually heard the case.
And yet, the people who are serving on that Senate Judiciary Committee continue to not just ask questions, but pummel away at it as if they didn't know or as if they didn't understand. I mean, in so many cases, comments are being made now that these senators who are on the committee are actually bloviating, are actually having their own public monologue to state their case that might be suiting their own political ends, and not fair, not relevant, but nevertheless it's prolonging what should never have happened in the first place, correct?
Well, yes and no.
Yes and no, okay.
What the senators can and should do is ask questions
Sure.
that the candidate should be able to answer about things that have already happened or written about in the past, and what their philosophy is.
Certainly.
And how they're going to approach a case, not about a particular case, but how you would approach it.
That's valid.
All of that is valid. And, you know, most of these candidates, especially for the Supreme Court, have been on other courts and have written rulings, and you can ask them about the rulings they've already written and how they came to the conclusion and what factored in, and get a feeling and a sense of their first of all, qualifications, and second of all, how they may rule and approach things down the road. And so a candidate who is in front of the court with a lot of history and writing and so forth, there's a lot of things that they can talk to them about and ask them about, which are appropriate. In this particular instance, there's also a question about the process and what about appointing someone so late in an election year with an election that's actually already begun? That's a different question, and that's what a lot of the senators have talked about.
Well, as I understood, this is the second closest to an election that a nominee has been proffered. So it's happened in election years before, and I think there was the time when Lincoln had his shot at it, and he said, I think I'm going to hold back and wait the election out. And in this case, they did not. So yes, if you're a Republican, you want someone's conservative, as they say, but not always. Same if you're a Democrat, liberal. Let's discuss a little bit how the nature of the governing body and those who are going to debate. There's an issue about filibuster and how that's worked, how that's changed, most recently how it's changed, and it does have an impact on how this process goes forward. Do you want to discuss that a little bit?
So
explain what a filibuster is.
Well, a filibuster is when a Senate on the Senate floor takes the podium and will continue talking so that a vote can't come up. And there's been some famous ones, not in the not too distant past, where they've gone on and on and on and actually tell stories and spend a lot of time, don't even want to take a bathroom break. But it's a way of a party that's in the minority of trying to stop the majority from ramming something through. But I do want to go back to one thing. You talked about Abraham Lincoln, and that appointment that he didn't make is actually something that really points to not only how smart he was, but his political genius too. And there was a book that, if you haven't read it, by Doris Kearns Goodwin, Team of Rivals, you absolutely should read. Great
historian she is.
Yeah, and in that particular case, the President Lincoln, didn't appoint someone to the Supreme Court just before the election, and he took the same approach outwardly about it's too close to the election, the people should decide. I think he was actually perhaps behind a little bit in his own mind.
I read that.
Yeah, and he had somebody everyone thought he was going to appoint, and that, as you know from the Team of Rivals, the people he had around him weren't actually people who particularly liked him or agreed with him, but he wanted to hear other points of views and bring those who may have opposed what he did closer to him and keep them, what they say, keep your friends close and your enemies closer. He wanted them close. He wanted to hear their opinions and value their opinions. And the person that everyone thought he was going to appoint may have been someone who would have campaigned against him or perhaps, pushed another candidate. And so by keeping that appointment and holding that appointment, he kept that person from being his political foe in many ways. So it was a political move that was genius and maybe was respecting the fact that people should vote before you appoint someone that close, but also using it for his own political motives. So it was a very complex decision, very strategic.
And we were talking about filibuster. That has changed in recent years. Do you want to speak to that?
I thought we did a little bit, but what more did I do?
So a little bit more about how that's changed recently with, actually McConnell was involved with this, right? 60, it was supposed to be majority, 2/3, then they went back to 60, which changed the composite and the nature of the voting.
Right, to stop the filibuster, the 2/3 majority had to vote, and then they lowered the amount, and they're talking about lowering it again, and which could potentially eliminate it at some point if they keep doing that.
Lively experiment is one thing, but this has become such a very contentious hot potato as well. What's cloture?
What's that?
Cloture.
I'm not.
So cloture, the idea of someone being able to a motion that lets them close down
or to stop the argument?
To stop the whole argument right there on the spot.
Right.
How does that work, David?
So I think it's just, there's a lot of arcane and different rules in the Senate and Robert's Rules of Order and all of those things that you have to follow. And I'm not a Senate parliamentarian, but basically they're all rules that are designed to try to keep the political discourse on track and give you ways, if something is getting rammed down your throat, filibuster to stop it, and ways to stop the filibuster so that you can bring things to a close and have a vote. And they're always, I love listening to it, but I have no idea what they're talking about sometimes with some of the Robert's rules and Senate rules.
The idea that you'd want to bring closure makes sense at some point because these 2- and 3-month Senate hearings seem to be ridiculous. But I guess some element of that closure aspect said that they can shut it down within 30 hours. That's still going to let it go on for some time. But when we're looking at the short term that we have right now before the election, I mean, we'd like to think that just because of the sheer numbers, that can't go on because the votes are there unless someone decided to change,
right.
And that's not going to happen. But the fact that that's even an element in place in our government makes a very interesting and evolving process.
And the thing is, the people who have been there for so long know the rules and how to push things through and get things done. And I think it is somewhat unfortunate. It's what I don't like about politics is when you say one thing that's good for you at one point and then change it when it's good for you to change at another point without there really being any change in the situation. The rules haven't changed, the facts really haven't changed. You just change how you approach them for your own political gain.
And didn't that happen even as recently as when Mr. Obama was president and then incoming president was 2016, where one of our senators declined to consider a nomination because it was so close to the election, and then now that he's got the reins, essentially, he's saying, no, I think we should vote right now because the president is still the president and it is the president's nominee.
Right.
It's very interesting how that kind of...
So they argue that the president shouldn't nominate someone so close to the election. And, of course, Obama did when Scalia died, and Trump did when Ruth Bader Ginsburg died. And the president should nominate someone. What the Senate does with it is another story. And that's the part of politics I really don't like. If you're going to not consider a hearing because it's too close to the election, then don't consider a hearing because it's too close to the election. And you can spin things and move things and change the goalpost and do whatever you want, but the facts are the facts, and really, you're just being a bit hypocritical.
Well, of course, out of that kind of process, one of the proffered nominees actually became a verb, to be borked, because he had issues, and we know what to be borked meant, stopped in your tracks.
But he got a hearing.
He did get a hearing,
yeah,
but stopped dead cold.
Yeah, and you know, if they gave that last fellow, Garland, a hearing, and decided not to vote him out, at least he got a hearing. But if you didn't give him a hearing, then you're saying because the people should decide, then don't say the people shouldn't decide. Just be consistent. That's all I'm saying.
And that's a point well taken. Well, I think we should be deciding these things. Thank you so much for tuning in to The Law Matters. As we say, it matters to you.